Good afternoon, Namibia and the world, and welcome to another Monday edition here of the Government Information Center. And today we're looking at the law. And the topic for this afternoon, we are looking at new bills that will be tabled in Parliament. My name is Desire Kahiha. I'm your host for this afternoon. And in the studio, we have Ms. Felicity Qovosis, and she is the chief at the Directorate of Legislative Drafting with the Ministry of Justice. Good afternoon, ma'am.
Good afternoon. Thanks for having me.
Likewise, we do appreciate you availing your time to assist us in understanding some of these things that take place in the high offices, and very little understanding really trickles down to us, and these platforms, we believe, we would like to help the man on the street to understand what is going on in Parliament. I will start with the first question, which is very basic. We're looking at definitions, meanings. When somebody's speaking about promulgation, for example, or passing a bill, or when a bill becomes a law, and commencement of bills, what does all that jargon mean?
Yes, thank you. Actually, it's important to know the terms that apply to law in order to understand the whole legislative process also, or the lawmaking. With the first one, the word promulgate, or when you talk about promulgation, it derives from a Latin word called promulgato, which means to make publicly known.
Okay.
So in our law, an act or a regulation must be publicly known, and how this is done is when the law is published in the Gazette.
Okay.
Only on publication in the Gazette can you talk about a law has come into operation or a law has been made. Yes, so that's what promulgate means. The concept of passing of bills, in the Namibian context, the Parliament is the lawmaking authority. Parliament is the National Assembly and the National Council. These two bodies, they constitute the lawmaking authorities. Now, at the third reading in each house, a bill will be passed, meaning it will be agreed on and voted on. So at third reading, a bill will be passed, meaning by simple majority, which is actually required for bills to be passed. So for example, when you talk about the National Assembly, 49 members who are entitled to vote must agree to the bill before it is said to have been passed. And then it will go to the second house, which is the National Assembly. So a simple majority is again required for a bill to be passed. That's when we can talk about a bill has been passed. Okay. The third aspect is when a bill becomes a law. You know that a bill is a proposal to make a law, whether it is a new law or an amendment to existing law. We'll be talking about a bill all the times that the proposed law is at Parliament. Now, once the bill has been passed by both houses, it has been signed by the President, and it has been published in the Gazette, then you can talk about an act of Parliament. Yes, that's the process. Another important aspect is the one for the commencement. When does a law come into operation? I know some people might think that once a bill has been passed and published in the Gazette, signed by the President and published in the Gazette, it comes into operation. No, unfortunately not. You have to look at the short title and the commencement provision in the law. Okay. The short title and commencement provision will guide you whether the law is in operation or not. Remember when I said it is a law, but it is not in operation, meaning you cannot do anything in terms of the law. Now the commencement provision usually would read, this act is called the Labour Act of 2007, and full stop. In such cases, that law comes into operation on the date of publication. Okay. In another instance, the law will say, this act is called the Labour Act 2007 and comes into operation on a date determined by the Minister by notice in the Gazette. That means the operation of the law is postponed until the relevant minister has issued a notice or published a notice in the Gazette stating the date on which it comes into operation. So that's an important aspect that the public should know when it comes to lawmaking.
Wow, okay. I won't lie. Today I am educated. No, today I am definitely educated, especially on the last aspect, the commencement.
Yes.
And I trust I am among many other Namibians who, would think it stops or starts being practiced or used once it's been published in the Gazette.
Yes.
But now I have a question. You spoke about the first house, the
National Assembly.
Yes, that has the 49 members. Now my question is, if they vote and not all of them are in agreement, does it still go ahead on a majority basis, or does it go back for reconsideration, or whoever was working on it to rework on it again? What happens there?
Okay, maybe let's first talk about if a bill goes through 3 readings in each house. During the second reading, if the House feels that there must be amendments to be made on the specific bill, this will be referred back to the office of the legislative drafting, and would do amendments which are called amendments on the floor. But that is different from a bill having obtained the required majority. Remember, I said that a simple majority is required for a bill to be passed. So a simple majority will be a half plus. But say now the bill does not have the simple majority, and it is not passed by simple majority. Such a bill will, the president is not obliged to assent to it, and it will be dealt with in terms of the relevant national standing, standing rules and orders of the National Assembly.
Okay.
Yes, because let me also mention that, say now a bill is passed by 2/3 majority at the National Assembly, and it is confirmed at the National Council. The president will be obliged to sign. But if a bill has not obtained the required 2/3 majority, the president is not obliged to sign the bill. Yes, he can decline to sign it, and then it can lapse. And also in certain instances, the president can decline to sign a bill if he feels that the constitutional issues are involved in the bill. So there are certain required majorities and quorums that need to be present before a bill can proceed to the next stage.
Okay.
Yes.
Okay. 2023, and we would like to then find out from you whether you can just give us an overview of the bills that are likely to be tabled in the National Assembly during the 2023-2024 financial year.
Yes, okay. So the first ones are the High Court Act, High Court Amendment Bill, the Magistrate Court Amendment Bill. These ones deal with the sale of the primary homes of debtors. Then you have the Marriage Bill. Then you have the Divorce Bill. You have the Uniform Matrimonial Marriages Bill. You have the Land Bill. You have the Ombudsman's Bill. You have the Vehicle Mass Bill. You have the Roads Bill.
Wow.
You have the Research, Science and Technology Bill. And let me just see if I did not leave one. And then you have the Roads Bill. Yeah, so those are the 12 bills that government intends to table in Parliament.
That is a list.
Yes, it's
that is a long list.
Yes.
They are definitely going to be keeping people busy for this financial year with that one. We always say here, it's a conversation that we're having. We bring in panelists in the studio to discuss topics that we feel are of national interest, and thus we always invite you to be part of our conversation. And at this point, we would like to remind you that we are streaming through our social media platforms, and you're always welcome to drop us a comment or question. And on YouTube, our handle there is MICT Namibia, MICT Namibia. That is on YouTube. On Facebook, you can find us at Ministry of Information and Communication Technology, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. Those are on our social media platforms. As we said, you can drop us a question in the comments or even add your 2 cents to the conversation. You can call us here in the studio. Our number is 061 400 397. 061 400 397. While I wait for you to come on board and enjoy this legal drive with me, I would continue with my questions then to Ms. Kovoses. And I would like to then find out from you, really losing your home is not the nicest of feelings at all, especially if it's not really your own doing per se. You know, struggles of life come along, issues with our financial institutions can also come in play. we never know. You know, retrenchments can also come in play. So most of the time you find people losing their primary homes through court processes that are instituted by these banks and local authority councils. How will the proposed bill that you alluded to a bit earlier on, proposed High Court Amendment Bill, address this issue at the High Court level?
Okay, thank you. Yes, it's true that a lot of people have lost, in fact, lost their primary homes due to this process or inability to pay the debts. Okay, so let me talk about what's happening currently. Currently, a summons will be served on you and you have 10 days to reply. So if you don't reply in 10 days, a judgment will be given to you. Now, how many people out there know what is in the summons? A lot of people are really not knowledgeable or can even read for that matter. Yes, that's the first aspect. The second aspect is the value of property is sold at 75% of the municipal valuation. Now, mind you, what is the municipal valuation? It's very low than the market valuation. So that's what's currently happening. The next one is when the auction is held or when the property is sold and the proceeds are distributed, say now to the creditors, and so the distribution plan or the proceeds plan is sent to you via registered post according to the current law. How many of us have access to, or do you really go and check your post? Or do you even have a postal box for that matter?
Exactly.
Yes, and currently also banking institutions are allowed to buy their own property. They can go and stand at the auction and rebuy their property and after 5 years resell it at the profit. So there's not really a lot of oversight. Another one is even if you have a primary home, you might not have the means to defend yourself. So with that in mind, what is the proposed law trying to do? So in terms of the proposed law, we are intending to increase the days for you to defend the matter to 21 days, from 10 to 21 days, to give people enough chance to defend the matter. The other one is, instead of looking at the municipal valuation, the court is allowed to set a reserve price, which will be at based on the market value, not the municipal valuation, to ensure that the debtor, if that is a last resort, can get something out of the property. The other one is also on the like I said, the distribution plan or the proceeds plan. We want to remove the reference to the registered post, and so that it's made available to the debtor and other persons through other means that are more accessible. Yes. Apart from that, we also want to put in safeguards to allow the Bank of Namibia to issue some determinations to look into the debt collection processes that are taking place currently in the banks, to see if those processes are really uniform. And also where the bank is allowed to buy property, to also have an oversight on how that process is regulated, because currently it's just left there and anybody can do what they want. So the other one is also, in the law, we also want to allow the Director of Legal Aid to look at granting legal aid to persons who are at the risk of losing their primary homes, because currently they're looking at the means test. So if you your salary is above 3,500, you would not qualify with the means test. So what if I just have the primary home, but I don't have other means to really approach a legal representative? So through this law, we also want to introduce that mechanism, which would make it easier for certain persons to obtain legal representation through government. So that is, in a nutshell, what the law is proposing to do.
Okay, but staying with the same law, how is this then at the magistrate court level? How what is being proposed at the magistrate court amendment bill? what is it to address with regards to this?
Yes. Okay, thank you. Let me just make the distinction. What differentiates the High Court from the Magistrate Court? The Magistrate Court is called a creature of state. It only has powers that the Magistrates Courts Act gives it. So its jurisdiction is also limited in terms of monetary terms, right? A High Court has inherent jurisdiction. It can hear and determine any matter, basically. So say now, your house is, so it depends on the value of the specific property. Say now the house is $500,000. Then it can be heard, for example, in the magistrate, if that's the mandatory jurisdiction of the High Court. But in terms of the proposed reforms, the same will apply when it comes, when it is dealt with by the High Court.
Okay.
Yes.
Okay. Please do join our conversation. As I said earlier on, we are open with regards to our telephone lines. 061 is the area code. The number here is 400397. 400397. Our handle on YouTube is MICT Namibia, MICT Namibia. And on Facebook, you can find us at Ministry of Information and Communication Technology, Republic of Namibia. Ministry of Information and Communication Technology, Republic of Namibia. We continue with Ms. Felicity here, and we would like then to find out, with regards to the divorce and marriage laws that you spoke about, what are the current issues that are being experienced, and how do the proposed reforms, how are they to deal with these issues?
Okay, so let me start with the current marriage law. So currently, the marriage law is kind of like outdated in the sense that it does not speak to the realities on the ground. Let me just give an example. Say now, Namibian citizen is to marry a foreign national. We have known that instances that people just want to enter into marriage for the purpose of obtaining citizenship, for example. But so there are no really strict regulation regarding this. So the other one is marriage officers may not always be knowledgeable or have the necessary training to conduct a marriage and to inform those marriages whom they are to solemnize, know in advance what is required from them or not. So it's not really regulated. Yeah, so the other one is currently there is no, say now you need to obtain a duplicate of your marriage certificate or a divorce certificate. It's so difficult because there's no centralized system. So what the Marriage Act or the proposed marriage law intends to do is, firstly, in terms of let me start with the obtaining duplicate marriage certificates or divorce orders. The Ministry of Home Affairs will be the central authority or the central point where you can obtain these certificates. And so institutions such as courts, for example, will be required, once a divorce order is made, will be required to send that divorce order, a copy of the divorce order to the Ministry of Home Affairs, for example, so that they are like the central repository of all these documents. The other one is it's introducing certain qualifications and trainings for you to be a marriage officer. So not any person can be a marriage officer, but you really have to go through certain training for you to be designated a marriage officer. The other one is it clarifies the concept of who can marry and who cannot marry, right? If you are a child under the age of 18 years, you are prohibited from getting married. Okay. Yes, you will be prohibited. But if you are between the age of 18 and 21, you need the consent of your parent or a legal guardian. But if through reasonable search your parent or legal guardian cannot be traced, you can be allowed to marry with consent being obtained. And of course, it also introduces very strict requirements for a Namibian citizen marrying a foreign national. There will be due diligence and checks done before this such type of a marriage can be can be done. Yeah. So.
Can you give us some of the possible elements that will be added to this law with regards to the Namibian marriage to foreign citizens?
Okay. For example, before the marriage, you need to obtain a marriage permit, meaning they will have a due diligence on a reference check on the specific foreign national. Has there been any criminal convictions? You know, things like that. They will look at verification of really the person's identity, nationality, issues like that will be checked. So it's more reference check to ensure that whoever, it's not only just for the merit aspect, but it's also for national security. Whoever is allowed in the country is really someone who is able to, is, for example, not a prohibited immigrant. Who is allowed to be, who can be allowed to stay in Namibia.
Okay.
Yes.
And then also going back to the shocking one. Ages of 18 to 21, you say. Okay, now from which parents do you need consent? Is it both sets of parents, the male and the female that are choosing to get married to each other, that are between these ages, or is it one of each?
Okay. Say now you are 25 and you want to marry the 18-year-old. So the requirement will have to, say now you are 25 and you want to marry 20-year-old, let me just say. The requirement will apply in respect of the 20-year-old, remember? But if it's two 18-year-olds or 19-year-olds getting married, you will have to obtain the consent in respect of both of them.
Okay.
Yes, so it will apply to the underage person.
Okay.
Yes, not the other.
No, not necessarily the. I mean, look, in Namibia we say the age of 18, you're considered an adult. You can, walk into a liquor shop and buy alcohol. Now, I'm sitting and I'm thinking to myself, okay, so we've got two 18-year-olds or two 19-year-olds that want to get married. For example, I have two parents, and both these parents of mine are not married.
Okay.
And do you need consent now from both, my father and mother, or would one parent consenting suffice? And what if one of the parents says yay and the other one says nay?
Yes.
What then happens?
Yeah.
And also, what if between the couple themselves, one side, the set decides no, the other set decides yes? What then happens in cases like these?
Yes, those are real practical problems that can arise. The thing with consent is your parent can be your adopted parent also, right? So it can be your biological parent, it can be any person that qualifies as a parent, right? Or a legal guardian. Now, your parent on the father's side, and sorry, I have to state that it does not matter, say now you have a mother and father, right? It does not matter whether the father was in your life or not, it's still your parent, right? Yes, such instances also arise. Or whether the person paid maintenance. Of course, you can raise these issues, but when we talk about consent, we don't discriminate and say only the parent who was taking care of the child can consent. I'll give you an example. When you travel with children to South Africa, right, the consent of the parent, say now you are the mother, the consent of the father is required. Now this father has not maintained that can grant you consent. So there are instances that can be, such can happen. So all I'm saying is it does not really matter the status or the profile of the specific parent. It does not matter whether they are married themselves or not also. So the parent remains the parent, unfortunately.
Okay, I don't know whether I should stay with this point
yes.
or let it go.
But let me just explain, because there will be instances that one parent or the one group unreasonably refuses because they might have issue with the other parent. In such instances, you can still approach the court, and the court can grant you consent as long as you can prove that, look, I sought, this person is refusing consent, they were not even in the child's life, blah, blah, blah. And then the court can give you, the court can waive, that requirement of consent still.
Because I was about to ask you,
what
is an example
no, because there will be
unreasonable?
gray areas like that. There are gray areas like that of unreasonably withholding consent.
Okay.
Or trying to be difficult.
Or
to be located.
Now you have the opposite, actually, would be my next question. Because what if you have this parent who really has not been a parent, per se, to this teen or person who wants to get married, and they're the ones who are saying yes? yet the actual parent who brought this child up is saying no. What then?
Or the actual parent is saying, oh yeah, then you actually have a good case for saying, I don't want my child to get married, if you can prove that. You understand? Because the other parent will not really have a case, will have a reason whether you should marry or not to marry.
Okay.
So it will more be a discussion as to what is your reason or rationale for granting consent, and what is the reason of the custodian, because that is a very important factor the court will look at. What is the reason of the primary caregiver, in this case which is the mother, for not wanting the 18-year-old to get married?
And what are some of the valid examples that you can give us right now that would actually constitute for these two not to be allowed to get married if the primary caregiver, for example, says no? What type of reasons would you then accept from that person who's saying no to validate and cancel or not allow this couple to get married?
I guess you have to look at, maybe sometimes it can be cultural reasons.
Okay.
Remember, customary law plays a very important part to say that my daughter has these certain habits, and this person that she's getting married to has these certain habits, and it seems they just don't want to get married for this and this. Or you can say, in my culture, this and this and this. There's no reason why they cannot wait until they are 19 or 21 or 22 to get married. So I think all of those will be rational reasons for you to withhold consent.
Okay.
Yeah.
No, this one is going to be a very interesting one. I think I will definitely be following it because our society will definitely, be questioning and probably approaching your office constantly to gain more understanding on why would, you want to put something like that in place, or how, one would go about utilizing the law.
Let me just say that when it comes to the marriage bill and the matrimonial marriages bill, it's the Minister of Home Affairs. They are the custodians. So right now, we cannot really do anything about it. If a member of public wants to raise issues, they can do it at the stage, or they can maybe ask the ministry itself, so the Public Relations Office, or they can wait until the bill is finally drafted, because policy might change in between. And at when the bill is at National Assembly, National Council, they can raise their issues there. Because like I said, right now it's still not a public document. I'm just talking about the proposals. So the public can still raise their issues once it's eventually introduced or tabled in the Parliament. Yes.
Okay. I stay with the Matrimonial Property Regime Bill, which is also known as Red Line Marriages Bill.
Sorry, I don't want to cut you. I didn't talk about the divorce one.
Oh,
let me quickly touch on
that. Sorry.
Okay, so what are the current issues with the divorce law? Currently you can only divorce someone on 4 grounds. You have to actually prove and state the facts. These grounds are adultery. The person has committed adultery. The malicious desertion. Malicious desertion is when you as the married person leaves the common home because the person makes it difficult for you to live with in the same home, or when the other party leaves the common home, like how some people are living separately. Yes, so that's malicious desertion. The other one is incurable insanity. Remember, these are old laws. So and the other one is when a person has been declared a habitual criminal.
Okay.
Yes, you are also. So those are the 4 grounds that you have to prove, meaning you have to actually state the facts that Felicity and whoever had a adult relationship outside of marriage, and there was a child born, and all those things that you have to prove before the court can. If you can't prove those things, the divorce will not be granted. Yes. So the other one is the rule that custody matters. If there are children of the marriage, custody must be sorted out before divorce order will grant it. And this is why some divorces take long, because the 2 spouses often battle about custody of the children. And the longer it takes, the cost also becomes high. And the other one is access to the court is limited, meaning only the High Court can make divorce orders. So
Okay.
meaning only Ventuken or Shakari can you get a divorce order. So that's the other one. Yeah, so in terms of, currently your pension is not really being taken into account. For example, say now you have a policy and you have a pension, the court cannot really make an order, say, order to a certain pension fund to say that Felicity must get a certain portion of the pension because he was married to you. But what are we proposing? We want to remove the grounds for divorce because the grounds of divorce are very limited. For example, what if I'm in an abusive relationship? What about domestic violence?
Exactly.
What if one of the parties to the marriage is misusing the financial resources? Every month the person, the salary is not coming in. It's just going to the gambling place or wherever the money is going. What if we mutually agree to divorce? What if we have simply fallen out of love and we just want a divorce? So that's what the new law is trying to cater for.
Yeah.
The other one is to currently, if you divorce, the court will first make an order what that is called the restitution of conjugal rights. What it means is go back to your wife and husband and do what you have to do. So during these processes, many things can happen. So it means you have to wait like 4 weeks before the final divorce order is granted. So we also want to abolish that specific order. Wow. Yes. The other one is we want to empower, or the ministry wants to empower the regional court to also make divorce cases, to cater for access to courts and stuff like that. The other one that we also want to deal with is the fair and equitable distribution of assets. The court must take into account, what if you are, say now you are, at the time of divorce, you are 60 years old and a pension payout is due to you in the next 2 months. Now, and you alone will benefit from that money. So the court can, having a look at all those benefits, make an order that is fair and just. Apart from that, the bill also deals with issues like spousal maintenance, which is already part of Namibian law anyway, and things like publication of divorce orders, or should divorces really be held in public? Meaning, because currently you have to go and appear in court to hear the specific. You have to go and take a stand like you are accused, and that can be very traumatic. So we are also looking at whether certain divorce orders can be granted in the absence of the instituting party. Yes. Yeah. We can move to the next one.
I'm still a bit baffled by the current situation, and I think it's understandable why changes are needed. I'm looking at forcing this person to go back for about 4 weeks to something that they had already decided they don't want anymore, and who knows what could happen in those 4 weeks. And it speaks back to gender-based violence, which is very prevalent in our communities.
Exactly.
We are quite a way, long way. We still have Ms. Felicity here in the studio. She is from the Ministry of Justice, and she's taking us through some of the new bills that are to be tabled during the 2023-2024 financial year. So time is not always on our side with regards to how many questions we want to throw at her, but we were looking to really try and pick out the important ones. And we have the Child Justice Bill, which is also on the list. And what changes are we to expect from the juvenile justice system once this bill becomes a law? Maybe you can just quickly give us highlights of those.
Yes. Okay, so this bill wants to look at the children that are in conflict of the law and that are accused of having committed the crimes. Because remember, the best interest of a child should always be the paramount consideration whenever any action is taken. So currently the children go through the normal criminal procedure process as like adults, which can be really traumatizing and which can be damaging. So the bill basically just looks at what restorative mechanisms can we introduce to divert children who are in conflict of law and to make them go back to society again, or what other sentencing options can we consider for children that are not really damaging. But of course, this will depend on the age of the child and the assessments done by the social workers. So in a nutshell, that's what that specific bill is trying to address.
Okay. Oh, yes, I was actually going to look into to one of the very, how do we call it, thorn in our sides as Namibians, and that is what is known as the Matrimonial Property Regime Bill, or also known as the Red Line Marriages Bill. Can you please explain, I think, the importance of the Uniform Matrimonial Property Regime Bill?
Okay. Yes, this one is very important. Currently we have what is called the Native Administration Proclamation of 1928.
Wow.
Yes. Yes. In terms of this proclamation, Section 17.6, if you are married north of the police zone, your marriage is automatically out of community of property, unless you, 1 month before the marriage, make a declaration that you wish your marriage to be in community of property. Those south of the police zone are not really affected, meaning those south of the police zone are automatically in community unless they enter into an agreement that their marriage is out. So the law is discriminatory, and this thing became applicable since 1 August 1950. Yes. So what happens currently is people who are in the north, and you see why also, or let me just say the current issues. If the marriage officer is not knowledgeable as to this requirement, right? Or if the parties, remember how many of the people can really read or know what the law requires. 1 month before, don't make that declaration. Then thinking most of the people think or thought that they are in community while they are in fact out of the community, just because of this proclamation. So this reform has been long overdue. So what the new law is bringing in is, it will give those that are married outside, north of the police zone, it will give them a certain period within which they can approach a designated magistrate, and where they can say, no, all this time our intention was that our marriage is in community, and based on that, the marital regime can be changed. But like I said, there will be certain processes that have to be followed. For example, there must be a notice that has to be published so that your creditors, because remember, everything will affect your creditors also. Say now someone gave you a home loan based on the thought that you are out or in community of property. You cannot just tomorrow decide that you are now out, because it will impact the creditor also. So yes, so they will be given a certain period in which they can make a decision whether their marriage was in and out. You will be surprised how many court cases are there that people actually thought they were in community whilst they were out of community, because they did not know about this specific requirement. Between the two of them, they agreed, but they never made the declaration 1 month before. Now, because that's now a formal part of the law that you have to be complied with. So what the courts would say is that they would look at, did these specific parties really intend to make an agreement? And that will be based on the facts and circumstances that the case presents itself. So the bill is trying to cater for those situations. And after the commencement of this specific law, parties will be allowed to choose whether they want the marriage to be in or out of community, rather than just leaving it to a system. And then they can decide which rules will apply to their marriage. If they want certain things to be out, or they can enter into anti-nuptial agreement, what is called, and then they can proceed on that basis. So in a nutshell, that's what this bill is trying to address.
Do you think, as we move, as our times move, and I always say the will of justice is a moving one. It's not something that stays stagnant and solid forever. Adaptation and readaptation is called for at times. Do you think we would one day have a system where some of these choices are not automatic, but the couple who intends to get married have to move and, you know, as you're saying, a certain time period before or so on, to state whether or not they want to be in community or out of community? you know, where it becomes formalized across board that you have to approach the offices a month or two before or after to state whether or not you want to be married in community or property or out, and not just for the sake of those that are now on the other side of the red line.
Yes. Okay, so maybe let me just re-emphasize what I said. What the bill is also proposing is that, just like you said, you will be allowed, once this specific law comes into operation, you will be allowed to choose which regime you're going to choose, whether you want to be in or out.
Okay.
So it's also catering for those situations, yeah, going forward.
Because I just wanted to get that clarity out so that people understand it's not just for those above the red line, it's across board.
Yes.
Okay, I think for our last question, it's very simple. We just want to find out from you, how has the Ministry of Justice engaged with stakeholders in the development of the bills for which the Minister of Justice is responsible, and what is the feedback that you have received from them?
Yes, okay. So let me just say, all these bills that the government intends to table, there are various ministries or ministers that are responsible for administration. The marriage bill and the matrimonial marriage bill, they are in the domain of the Ministry of Home Affairs. Justice's High Court Amendment, Magistrate Court Amendment, the divorce bill, and the child justice bill, and the ombudsman's bill. So with regard to those, especially the divorce bill and the child justice bill, the ministry has developed a child justice policy that will precede, or that preceded the drafting of the specific legislation. And in this regard, consultations were held with the various offices, ministries, and agencies who perform functions relevant to what the bill is trying to deal with. For example, Ministry of Gender, Ministry of Home Affairs, and likes of that. And the divorce bill, you know, most of the bills have actually come a long way. It's not new legislation, but because of institutional changes of ministers and things like that, there has been some delays. So on the divorce bill, for example, the reform process started a long time ago, 2009 or so, and the Law Reform and Development Commission made some reports. Between 2018 and 2022, various institutions were consulted, which is the civil society, the Office of the Judiciary, who is actually responsible for implementing it, the legal fraternity, and the public, just to cite a few.
Okay. Well, with that said, we unfortunately would need